This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only.
Hey, Jamie Carper here. Today's case is about the Eighth Amendment, evolving standards of decency, and the absolute outer boundary of the death penalty. The case is Kennedy v. Louisiana, 554 U.S. 407-2008. Here's the background. Patrick Kennedy was convicted in Louisiana of raping his 8-year-old stepdaughter. The crime was horrific. Louisiana law allowed the death penalty for the rape of a child, even when the crime did not result in the victim's death. A jury sentenced Kennedy to death. The Louisiana Supreme Court affirmed the sentence, holding that the death penalty was constitutionally permissible for child rape, given the severity of the offense and the state's interest in protecting children. So the case arrives at the U.S. Supreme Court with a stark question. Does the Eighth Amendment permit the death penalty for the rape of a child when the victim does not die? In other words, is death a proportionate punishment for a non-homicide offense against an individual? That's the issue before the court.
We'll hear argument this morning in Kennedy versus Louisiana.
Mr. Chief Justice, and may it please the court. Child rape is among the most devastating crimes imaginable. It permanently scars the victim and destroys lives. The state has a compelling interest in imposing the severest punishment available to deter and condemn this offense.
Is your position that child rape can be worse than some murders?
Yes, Justice Alito, a child may live with lifelong trauma that death would end.
But our cases emphasize proportionality. Historically, has the death penalty been imposed for non-homicide crimes against individuals?
The Eighth Amendment must evolve with society. Several states authorize death for child rape, reflecting contemporary standards.
But the number of states actually imposing it is small, correct?
The trend is emerging, Justice Ginsburg.
Mr. Chief Justice, and may it please the court. The death penalty is categorically disproportionate for crimes where the victim does not die. The Eighth Amendment forbids punishments that are excessive in relation to the offense.
Isn't that a moral judgment more than a constitutional one?
The Constitution requires the court to assess proportionality using objective evidence, history, legislation, and jury practices.
What does that evidence show?
A national consensus against executing offenders for non-homicide crimes against individuals.
And the risk of unintended consequences such as discouraging reporting?
Yes, the death penalty may increase pressure on victims and incentivize offenders to kill witnesses.
The Eighth Amendment requires proportionality. Death is unique in its severity and finality. Our precedent limits it to crimes where the victim's life is taken.
Child rape is uniquely devastating. The harm is profound and permanent.
It is, yet the victim survives. Our cases draw a constitutional line between homicide and non-homicide offenses against individuals.
And the objective evidence shows no settled national consensus supporting execution here.
The court is substituting its judgment for that of legislatures.
We are enforcing a constitutional limit. The Eighth Amendment is not a popularity contest, but consensus matters.
Expanding the death penalty here risks eroding its limiting principle.
The Constitution demands restraint. Severity alone cannot justify death where life was not taken.
Justice Kennedy has the opinion of the court.
The court holds that the Eighth Amendment bars the death penalty for the rape of a child where the crime did not result in the victim's death. The death penalty is disproportionate punishment for a non-homicide offense against an individual.
Here's the holding. The Eighth Amendment prohibits the death penalty for the rape of a child when the victim does not die. That's Kennedy v. Louisiana. Why does this case matter? Because it draws a constitutional line. The Supreme Court said that no matter how horrific the crime, the death penalty is reserved for crimes that take life, not those that devastate it. The court relied on proportionality, national consensus, and the principle that death is different, final, irreversible, and constitutionally limited. This decision did not minimize the crime. It limited the punishment. I'm Jamie Carper. And remember, under the Constitution, even the worst crimes do not erase constitutional boundaries.